So today we'll look at about the intellectual property. So you know that there are various products in a market are available publicly. These are the product of human creativity. These are the product because of a specialized human skill, and these product are having a worthful meaning, means they have a very much importance in our life. So the intellectual property, we are going to see what is intellectual property, what is the meaning of intellectual property, what are the different forms of an intellectual property, how the human creativity, how the human skills are protected by this intellectual property. If it is protected by this legal document, if these intellectual things or human creativity or human skill, if it is protected by the legal document, then it is valid for how much year? Where we can protect, or when we can apply for the protection of our creativity, protection of our skill, protection of our product, where shall we should go and we shall apply for it? Then what is patentable in India? What is non-patentable in India? What is Plant Variety Protection Act? What is Plant Breeders Act? What is Farmers' Right? So all these things I've been going to cover in today's lecture. So before going to the in detail about this intellectual property, I would like to ask you, do you know how many offices or how many centers our country is having if we have to go for a legal protection in the form of intellectual property for our product or for our creativity or for our skill? So there are 4 offices all over the India. There are 4 offices where we can do the registration of patent, where we can do the registration of trademark, where we can do the registration of trade secret, where we can do the registration for industrial designs. So these offices are located at Mumbai. One is at Mumbai, one is at Kolkata, one is at Delhi, and one is at Chennai. So in total, there are 4 offices where in India, there are 4 offices where you can register your product, your trademark, trade secret, depending on the your locality. So if you have a domicile of an in Maharashtra, then you have to report for the patent, for the trade secret, for the trademark, or for the copyright to the Mumbai Patent Office. If you are belonging to the Karnataka, if you have a domicile of Karnataka, then you have to report. If you have to register for the copyright, if you have to register for the trademark, if you have to register for the trade secret, then you have to go and you have to apply at Chennai Patent Office. Similarly, if you are having a domicile of eastern state like West Bengal or Northeast state, then you have to register, you have to apply for the registration of intellectual property like patent, trademark, trade secret at Kolkata Patent Office. Those who has domicile of Himachal Pradesh, Rajasthan, then Punjab, then Haryana, Jammu and Kashmir. So if they would like to register for a patent, if they would like to register for a trademark, trade secret, copyright, or industrial designs, then they have to apply at Delhi Patent Office. So what I have to say here, in India, there are 4 offices or 4 headquarters to register the intellectual property: Mumbai, Chennai, Kolkata, and Delhi. So what are the types of this intellectual property? So this intellectual property means it can be exist in the form of patent, it can be exist in the form of trademark, it can be exist in the form of trade secret, it can be exist in the form of copyright. So these all are the forms of intellectual properties. Which are they? These are patent, trademark, trade secret, copyright, and industrial designs. So there is one forum. We call it as an intellectual property organization, World Intellectual Property Organization. Okay. So there is a forum. We call it as an WIPO, that is World Intellectual Property Organization, which is established in the year 1967, and it is the agency of United Nations and which promotes the protection of IPs throughout the world. Its headquarters is in Geneva, Switzerland. So WIPO stands for World Intellectual Property Organization. And where is the headquarters of that WIPO? It is in Geneva, Switzerland. Because as you know, when we say about the trade, when we say about the business, when we say about the trade with the other countries, when we say about the trade, when we have to deal with the other countries, so it can be dealt through various trademarks, trade secret, right, with the brand names. So how to regularize this trade all over the world? Okay, because if I have invented something and if it is being copied, or if it is being duplicated by someone without my permission, then it is the against of law. It is against of intellectual property rights. So this World Intellectual Property Organization, which has a headquarters at Switzerland, Geneva, Switzerland. So it controls these trades, it monitors, it regulates all the trade worldwide. If there is a violation of this trade in the form of intellectual properties like trademark, trade secret, copyright, patent, then there will be a punishment. There will be a that means there will be a case registered against him. There will be a penalty to that country or that particular organization. So this World Intellectual Property Organization is monitoring, is regulating all these things worldwide. So you should know about WIPO, what it stands for, World Intellectual Property Organization. Where is the headquarters of this WIPO is present? It is Geneva, Switzerland. And what is the role of this WIPO? Because it regulates all this intellectual property, means it regulates the trade in the form of intellectual property. Because if you have to come in the market, we have to come with the trade. You know, there are Coca-Cola, there is Pepsi, there is Apple, there is Sony, there is Vivo, there is this one, you know, that means trade name. With the trade name, the market, that means there are various firms, they are coming with the product with some certain trade name, okay, and with some certain trade mark, okay. So we have seen the various trademarks available. That means on a cold drinks like Pepsi, Coca-Cola, there is a trademark. If you took any equipment you can take. If you take a laptop, there is a HP. If you take a laptop, there is a Lenovo. If you take a TV, it is Samsung. So there is a trademark. Okay, it should not be misused by any other firm. So this can be monitored by this World Intellectual Property Organization. So the next thing, this World Intellectual Property Day, it is being celebrated in the month of April. So 26th April is the date when World Intellectual Property Day is being celebrated. 26th April, that also you should know. So intellectual property law in India. So in India, as you know, that World Intellectual Property Organization, and India is also a member of that World Intellectual Property Organization. India is also dealing with the various trade through this intellectual property with various countries, and it has some laws in India to protect such intellectual property, which is the product of human creativity, which is the product of human skill. Okay, so to protect such a intellectual property, there are some laws in India. So when we talk about this intellectual property, first question comes in our mind that what is intellectual property? Okay, I told you that it may be a human creativity, or it may be a skill, it may be in the form of product, right? So intellectual property is the property that arises from the human intellect, and it is the product of human creation. It is the product of human creation. So intellectual, what we comes from the human intellect, and whatever the product that comes from the human intellect. So to protect such a intellectual property, the Indian system are having such some laws like World Intellectual Property Organization. So this intellectual property compromises the various forms. It is maybe an industrial property, it may be a literary and artistic work. You know that there are copyright, there are trademarks, there are trade secret, there are industrial designs. So all these can be protected by this intellectual property. So whatever the outcome, whatever the product of human intellect, it is protected, or human creation, product of an human creation, it is being protected by some laws. Okay, that is intellectual property laws. So intellectual property means it is a property that arises from the human intellect, right? So what are these different forms of an human intellectual properties? So first you should know that copyright, you can take any book. So there is a symbol of C, and there is one circle is there. So that means it is protected by the copyright. So there are some books, there are many books, there are paintings, there are musical compositions like CDs, DVDs, there are movies, radios, TV programs, and other artistic work. So they are protected by the copyright. They are protected by the copyright. Means if I am an author of a book, if I am writing a book, and I am giving an authority to some publishers to publish it, so nobody should misuse that. Okay, even if you are taking a xerox of that book, means is a violation of that copyright. It's violation of that copyright, because whatever you do, it's without the permission of your own author. It's without the permission of publisher. So the copyright means we have to purchase the new book instead of taking the Xerox copies. Okay. So this literary and artistic works is being protected by the copyright. And what are these literary and artistic work? They may be books, paintings, musical compositions, movies. Okay, so this can be protected by the which type of intellectual property? It is protected by the copyright. So what is the industrial property? What actually the industrial property? It describes the physical matter that is the product of an idea or concept for commercial purpose. Okay, so when we talk about the intellectual means it's a product of an idea. Okay, so industrial property means it describes the physical matter that is the product of an idea or concept of an human purposes. So how they are being protected? It may be protected by the patent. It may be protected by trademarks, like I told you that Samsung, then LG. Okay, it may be protected by some industrial designs. It may be protected by trade secrets like composition of various cold drinks, composition of pesticides, composition of insecticide, composition of any medicine. So that is protected by these trade secrets. So whatever the formulations are there, which ingredients are there, right? Then geographical indications. See, now in recent days, there is a geographic indication. There is one more property has been included, that is geographic indication. It has some, that means when we talk about the intellectual property, I told that it is the product of human intellect. It is a product of human idea, human intellect or human idea. And how these being are protected? It is protected by patent, trademark, trade secret, industrial designs. So suppose if I have a this one, I have a new vehicle. I have designed a new vehicle. That is, suppose you can take any vehicle. Suppose I will take one car, that is Mercedes, and I have a design and one new designs I'm having for that Mercedes. So that you can register. If I have developed a one small machine, so that you can register. If I have some formulation for a particular biopesticides or pesticide, that you can register. If I have a one good product, that you can patent. But what about geographical indications? Where actually there is no involvement of any human intellect. Actually, it is the product of that particular climate. It is the product of that particular weather conditions. For example, in the geographic indications, what will come there? You know that in Nagpur, oranges are there. Okay, you will not get that much that taste anywhere else. So that Nagpur oranges are being protected by this GI, geographic indication. Nasik grapes, they are protected by this GI, geographic indication. Solapur chadar, okay, it's protected by these geographic indications. Dharwad pedha, it is protected by this geographic indication. Our Ratnagiri hapus, Raigad hapus, because that taste you will not get anywhere. No one can sell the Raigad hapus or Ratnagiri hapus with the name of Ratnagiri, with the name of Raigad. No one can sell the Nagpur oranges, like oranges which has been obtained from Nagpur. They only can sell the Nagpur oranges in that particular name. So that is the geographical indication. Okay, Agra's petha. Okay, so that is the geographical indication. That will come to the geographical indication, because whatever the taste, whatever the flavor that has been incorporated into that product, so it's because of that particular weather conditions, it's because of that particular surrounding conditions. But and there is no human directly involvement of a human intellect. Okay, but still it is coming in the intellectual property rights. So there is one more industrial property or intellectual property right, that is geographic indication. So like patent, trademark, trade secret, industrial design. So there will be one more property, intellectual property, that is geographic indication. So the major types of intellectual property, that is the product of human mind, that is the product of human skills. So they are functional and technical inventions. So whatever the functional and technical inventions which has some worthful values in a market or for human beings or for a society, so that comes under the Patent Act. So Patent Act 1970, Patent Act 1999, Patent Act 2005. Actually, original Patent Act is of 1970, but after that there are some amendments in the Patent Act 1970. Okay, so the amendment took place in the year 1999 and 2005, but original Patent Act was formulated in the year 1970 by Government of India. Then there is another form of intellectual property, that artistic work. I told you about books, music, CDs. Okay, so that can be protected by that artistic work can be protected by Copyright Act. The original Copyright Act was given by the Government of India in the year 1957. So whenever we talk about the act, so this act means it gives us the idea that how it is being protected, how much time it is protecting, what are the rules and regulations of this copyright, who will the person who violates that rules and regulations, the persons who will violate that intellectual property regulations, what are the punishments given to him. So all these things will cover under the Copyright Act. So the Copyright Act will become it has come in the year 1957, and there are also amendments in the Copyright Act in the year 1982, 1984, 1992, and 1994 and 1999. Similarly, the artistic work is protected by the Copyright Act. Similarly, a symbol, like I told you, that Samsung, then a logo, maybe your university logo, you can take word, any word, okay, sound, any music, then color, then design, etc., that can be protected by the Trademark Act. So Trademark Act has come in the year 1999. Okay, you should remember the year. The Patent Act, it has come in the year 1970. Copyright Act, it has come in the year 1957, which deals with the various artistic works. Whereas a symbol, a logo, a word, any sound, a color, a design, it comes under the Trademark Act 1999. Okay, so the year and that act you should remember, and what type of intellectual property it covers. Like artistic works, it can be covered by the Copyright Act. A symbol, a logo, word, sound can be covered under the Trademark Act. So right now, those who are unaware about this intellectual property rights, those who are not having that much knowledge of intellectual property rights, they may ask the various questions like, can I patent my copyrighted trademark? So what I have to say here, patent is the other form of intellectual property. Copyright is the other form of an intellectual property, and trademark, they are the separate forms of an intellectual property. So those who are unaware about this intellectual property, because if they say that, okay, I have a word, I have a sound, which I would like to patent, so it is not coming under the patent, where you should apply it under the trademark. If I have published a book, if I would like to publish a book, so I should not ask, okay, where I have to patent my book, or I should not ask where I have to trademark my book. It should be copyright. It's come under the Copyright Act. It's come under the copyright of an intellectual property. If I have some formulations, if I have some pesticide formulation, if I have any ingredients, I know the ingredient and that's working well, which giving and promising results. So it comes under trade secret. So we should not go like, I have formulations and then I have to go for the Copyright Act. Okay, so whatever the inventions will be there, whatever the new things we will discover, so that comes under the various forms of an intellectual property. Either it will come under the patent, either it will come under the copyright, either it will come under the trade secret, either it will come under the trademark, or either it will come under the geographic location. So if there is some geographic location, so Nagpur oranges, it will not be get patented, it will not get to copyright, it will not get trademark. Okay, trademark you can design, but Nagpur oranges comes under the geographic indications. Kolhapur chappal, Solapur chadar, Agra's petha, okay, Dharwad peda. So this all comes under the geographic indications. Now, as I told you, various inventions or various inventions or which has been invented by the inventor, either it comes under the it comes under the various forms of an intellectual property. So we'll look at the one patent, that is one form of the intellectual property, one type of an intellectual property. So as I told you, the Patent Act has come in the existence in India in the year 1970, and it is there are some amendments in the Patent Act which has come in the year 1970. So it extends to the whole of India. See, all these intellectual property forms or types of an intellectual property, it may be patent, it may be trademark, it may be trade secret, it may be a copyright. So they are territorial in nature, they are time specific. Means whatever the legal authorization you will get for discovery of such a or for making a trademark or for making a copyright or for making a trade secret or for making a patent, whatever the legal authorization you will get, that is territorial in nature, that is time specific. It means it is specific to the some particular location. So right now, whatever, so if it is coming under the Patent Act 1970, means, as I told you, if you have to register your intellectual property, maybe trademark, trade secret, trade copyright or patent, you have to approach to the four different centers of India. It is Mumbai, it is located at Mumbai, it is located at Chennai, it is located at Delhi, it is located at Kolkata. So if I will register my invention or if I will register my product in a Mumbai office, means it is applicable all over the India because it comes under the Patent Act 1970, but it is not applicable to the other countries. Okay, so it comes under the Indian Patent Act 1970. So it shall come into the force on such a date as the central government may publish by notification in the official gazette. Okay. So what is patent? So what is patented or what is not patented? That will be I will cover in the other part. Okay, that I'm going to cover in the other part. That will be maybe after 20 to 15 slides. I will cover that one. What is patented and what is not patented in India? What is patented in US? What is not patented in US? What is patented in the European Union? What is not patented in European Union? Okay, so that I will cover in the after some time. So we look at the definition of patent. A patent describes an invention for which inventor claims the exclusive right. So all rights are with the inventor, because when we say that invention is patentable, when we had to say that invention is patentable, if that invention is novel, because no one scientist or there is no any discovery with respect to that invention, it should have usefulness, worthfulness, it should have some society, it should help to the society, it should help to minimize the time, it should help to for some work, or it has some worthful meaning. It is not obvious. Not obvious means it cannot be made by layman. The invention, it is not that much easy to invent. It cannot be that made that much easily. So it is not obvious, right? It pertains to the patentable subject matter. So what inventions can be patentable? So it should meet the following criteria. Whatever the invention you do, whatever the things you invent, so that should be novel, that should have some industrial applications, that should be have usefulness, it should be worthful, it is not obvious to any layman, it is not easily can be made by any person or unskilled person. So such an invention which has an industrial application, which has a novelty, that can be patented at the various patent office of India, which gives a right, exclusive right to the inventor. So what are these patentable subject matter? As I told you, What is this invention? It should meet the criteria of novelty. It should have an industrial applications, right? So patentable subject matter, it relates to a process or product or both. So what can be patented? You can patent a product and you can also patent a process or methodology. What you can patent? You can patent a process or you can also patent a product. So it should have an inventive step. It should have a novel step there. When you formulate and process, when you formulate and product, and it should have an industrial application. It should be having a worthful technology. It should be a worthful technology. So that is patentable subject matter. Okay. So what you can patent? You can patent process. You can patent a product. It should have an inventive step. It should have an industrial applications, and it should be novel. It should have novelty. So such inventions you can patent. I repeat, the invention which has a novelty means no one has discovered it worldwide. You can patent a process or you can patent a product. The methodology or the steps we can follow for that invention, it should have an inventive step. That means some new methodology should be there. And most important thing that it should have an industrial application. It should have a industrial application. So like this, these things can be patentable. So patent is one form of the intellectual property. So what is the duration of patent? So the term of the patent is 20 years from the date of filing for all type of inventions. Suppose I have made an inventions and now I would like to patent it. So I will file that patent in any office of the Indian Patent Office. There are 4 patent offices in India. So I will find the in any of the depending on the locality, I will file the applications for the patent in any one of the office in the India. Okay, so that duration for that patent is 20 years. And that is from the date of filing, not from the grant of patent. See, if I have filed a patent in the year 2020, and right in 2022, I am getting a grant or I am getting a approval. That means patent is granted by this patent office. Means that 20 years duration will start from the date of filing. Means inventor will have the exclusive right on that invention or innovations for the time 20 years from the date of filing. If I will file it from the 1st of January 2019, then it will be valid till 31st of December 2018, means 20 years of time. So time starts when you file that patent. Filing of patent is different and granting of patent is different. So filing of patents means when you file a patent. Okay, and granting of patent is different. So the time of that duration of that patent is 20 years. And from which date? It is the date of filing, not from the grant of patent. Okay. So the term of patent is counted from this date. You should remember that the term of patent or duration of patent is 20 years from the date of filing for all types of inventions. So there are different fees which have to be which we need to be paid to the various offices in the patent offices which are located in the which are located in various metropolitan city. So the government fee for filing a patent application in India is rupees 750 for individuals and rupees 3000 for legal entities. So for 750 for individuals means if there are 4 innovators, if there will be, see, innovators may be 1, innovator may be 2, or innovator may be 3, or it may be more than 1. So for each individual, it is 750 rupees per individual. Okay, then there will be no fee for first and second year. But after that, renewal fee should be paid on yearly basis. That means from 3rd to 20th year of patent, you have to pay the fee to the patent office, okay, for the authorization of that or for the rights of that patents. You have to pay the renewal fee from the third year to the 20th year. So for first year and second year, there is no renewal fee. So there will be a question, is a patent granted in one country enforceable in other country? Answer is no. There is nothing like a global patent or world patent. Patent rights are essentially territorial in nature. So whatever the patent if we register in India, so if it is coming in Indian Patent Act, that is only for India. So they are territorial in nature. But right now, the patent can be registered throughout the world also. That is with the patent cooperation treaty. So there is one agreement within various major countries. Okay. So that is patent cooperation treaty, the country. So India is the member of that patent cooperation treaty. So there are suppose 50 members who are the members of that patent cooperation treaty worldwide. So there that patent can be granted in other country also. That is PCT, patent cooperation treaty. But in general, the patents are very territorial in nature. Okay, they are very specific to the particular location. Like granting a patent in one country of the United Union does not force other countries to grant the patent for the same invention. The refusal of the patent in one country doesn't mean that it will be terminated in all the countries. So it is territorial in nature. It is time specific, like 20 years. It is territorial in nature, means it is suppose it is Indian Patent Act. So it is relevant to the only India. So patent holders in India, there are various pharmaceutical company, biotech industries company, they are filing a patent with various medicines and everything, they are being patented at various patents office in the India. There are 4 patent office in India: Mumbai, Chennai, Kolkata, and Delhi. See, this is the patent certificate. This is the grant of patent. Okay, this is how it look like. The Patent Act. Okay, so this is the, once you get a patent, you will get a patent number. Okay, for that patent. So patent is one of the type of intellectual property we have seen. We have seen it is territorial in nature, time specific 20 years, where to file a patent. Okay, and what is the duration of that patent? What is the renewal fee? How much amount of registration fee is needed if you have to file the patent? So there is another form of an intellectual property, that is a trademark. That is trademark. So it is covered under the act called the Trademark Act 1999. So it is covered under the act called Trademark Act 1999. So this act came into the effect from on 15 September 2003. Okay. So Trademark Act, it has been come in the year 1999. It extends to the whole of India. It shall come into the force on such a date as the central government may publish by notification in the official gazette. So trademark, what is trademark? It may be a symbol, it may be a logo, it may be any word, it may be a sound, it may be a color, it may be a design, which is used to identify a business or a product in commerce. So any symbol, I told you that you can take any product, you can take Bisleri bottle, you can any that means cold drink, any bottle, you can take any pharmaceutical product. So that has one trademark. It may be in the form of symbol, it may be in the form of word, or it may be in the form of logo. So when it has been advertised, it is in the form of sound. So there are different symbols which are used to give. If you see any product, so there it has been written TM. TM means it is intent to use application field for product. So trademark TM. Okay, TM means trademark. You can take any product. So at corner it has been written as TM. It means it is the intent to use application field for product. So that has been protected under the trademark. That product has been protected under that trademark. Okay, no one can use the Bisleri trademark. No one can use the Coca-Cola trademark. No one can use the Pepsi trademark. Okay, so they are protected under this Trademark Act. You can also see the SEM at the right corner of various products. So this is the symbol which is used for services, like some agencies which provide the security services. Okay, suppose Garuda agency, which is the well known for the providing the security services. That means they provide some manpower for the security personnel they will provide. So how they are indicating their trademark? It is indicated by SM, means service. Okay, yes means service. They are providing some services. It's also come under the trademark. Then you can see the capital R, and there you can see it is under the one circle. That is the registered trademark that has been registered. Okay, so registered trademark. So you can see any product. So there it has been written R. So that is the trademark, and it is the type of intellectual property. So registration procedure is same. That first we have to, whenever suppose I have formulate one trademark, I have to formulate. First we have to look for, is there any suppose right now if you can have ABC trademark, okay, that is word, but you should be you should be very much aware that no one is using that ABC word trademark worldwide. You have to search. You have to make a global search. Okay, there are some search engines which provide such information, because that should have the novelty, that should be unique in nature. Okay, there should not be duplication of this trademark. Otherwise you will be filed for penalty. If somebody is already registered and ABC and you are registering that ABC as a trademark, then you will get punished. You will be behind the jail. You have to give the you have to give the compensation. Okay, so you have, before registration you should be very much careful that nobody is using that one. So like patent is valid for 20 years, this trademark is valid for 10 years from the date of application, which may be renewed for further period of 10 years on payment of prescribed fees. So patent is being renewed from 3rd year to 20th year. So trademark can be renewed after each 10 years because its validity time is 10 years. But patent is patent that you can't renew after 20 years. It has at some time, that is 20 years. And after 20 years, that patent is publicly available. There will be no right of the inventor on that particular patent. So service mark rights are reserved exclusive for owners for 17 years. So service mark you have seen that TS, it is for 17 years. So whatever the government fees is 2,500 for each class of goods or services. So there are different kinds of services like pharmaceutical goods, agriculture goods, agriculture services, pharmaceutical services, medical goods, medical services. So under which goods and services you would like to register that trademark? That is very, very important. Okay, so which product is there? Which product is that? Whether it is an agriculture product, then it should come under that particular section. If it is a medical product, that trademark should come under that particular section. Okay, so the duration of trademark is for 10 years and it can be renewed for after the 10 years. So a trademark is a sign which is used on or a connection with the marketing of goods and services. So Raymond Textile is the India's leading producer of the worsted suited fabric with over 60% market share. Okay, so how to write this Raymond Textile? That is important. Whether we should write italic, whether we should write non-italic. So that defines the correct use of that trademark. Here we can see there are different trademarks. Their size and these things very, very specific. There you can see the Vimal, ADT. Okay, so how the incorrect use, you can see the Vimal, how it should look like, ADT, how it should look like. You know, Polo is there, how it should look like. Raymond is there, how it should look like. So these are the trademarks. They are having some defined diagrammatic presentations, like this much centimeter length, this much centimeter of that, millimeter of that A symbol, this much circle should be there, this has this diameter. So this is very, very defined. Okay, so that this trademark plays an important role when we talk about the trade. Then you can see Calvin Klein, okay, Tommy Hilfiger. So these are the various trademarks. So you can see the name. So Coca-Cola, it is the name, it is the trademark. You can see that logo type, it is also a trademark. McDonald's symbol, you can see slogan, I'm loving it, that also a trademark. Shape, that is also a trademark. See how the shape of bottle is there. Color, that orange TM. So that is also a trademark. So trademark, it may be a name, it may be a logo type, it may be a symbol, it may be a slogan, it may be a shape, it may be a color. Okay, so you should know that what is the trademark, what is the duration of the trademark, what is the how we can renew, what is covered under the trademark, what is covered under the patent, what is covered under the, what is the duration of patent, how we can renew it, what is the fees required to pay at patent office. Then comes to the copyright. So I told you that various artistic work, it comes under the copyright, like books, paintings, music, compositions. So Indian Copyright Act has come in the year 1957. There are amendments in the year 1982, 1984, 1992, 1994. So what's this meaning? It is the right which grants the protection to the unique expression of ideas. Unique expression of ideas. It is the right which grants the protection to the unique expression of the ideas. So the term originally in the copyright law means that work originated with the author. Suppose I have written one book, means I am an author for that. Okay, so that has been originated from me. And if you are taking a Xerox, means Xerox of that books without permission of me, without the permission of author, it is the violation of intellectual property. So there is no requirement for novelty and uniqueness as there in patent law. So patent means if you have to do the patent for some particular invention, so I told you that it should be novel, it should be non-obvious, it should have an industrial application, it should have an inventive step. So all these such a criteria that particular invention should meet, then only we can apply it for the patent. Then copyright law, which protects the expression of an idea. So what is covered under the copyright? We have seen what is covered under the trademark. Similarly, we should know that what is covered under the copyright. So literary work like books, films, dramatic, musical things, artistic work, and various sound recording compositions. So all comes under the copyright. So you know the copyright, how it is denoted, the copyright symbol is C and there is one circle. That is the copyright. Okay, so what comes under the copyright? Literary, films, dramatic, musical, artistic, sound recording like CDs, DVDs, books. Okay, that comes under the copyright. Trademark, we have seen logo, name, slogan, music, that's come under the trademark. So what is not covered by the copyright? So ideas, facts, recipes, that's not being covered under the copyright. So what is the duration of copyright? So the copyright right, suppose if I have written a book, so I am having a rights to that books till my lifetime. So author's lifetime plus 50 years from the end of the calendar year in which author dies. Means if I have published a book during the 30th year, and if I will live for 70 years, so after that 70 years, again for 50 years that authors will have the right, and that author can nominate some person to have his right. Okay, so author's lifetime plus 50 years from the end of calendar year in which authors dies. For such a longer duration, that copyright legal authorization that authors will get. So it's author's lifetime plus 50 years. Patent is for 20 years. Trademark is for 10 years, and after 10 years you can renew it. Copyright is for author's lifetime plus 50 years from the end of life death of author. So if you violate all these things, if you violate all this intellectual property, if you do the violation of this intellectual property, it's called as infringement. It's called as infringement. Means if you take, if you misuse the patent, if you will not take the license from the inventor for using this patent for its commercial use, then there is a violation of that patent act. And this phenomenon we can call it as an infringement. If you do not take an author's permission, if you would like to copyright that particular book, so this phenomenon we can call it as an infringement. So whenever there is an infringement, whenever there is a violation of that intellectual property laws, Copyright Act, Trademark Act, Patent Act, so at such a all time, that particular person should get punished. That particular person should compensate, pay the compensation. That particular person will be in the behind the jail. So all these things, punishment will be there if there is an infringement of that particular intellectual property. So there are, you can file a case against that particular person who will misuse your intellectual property or your rights, which has been given by you by the Indian Patent Act or by the Copyright Act or by the Trademark Act. So now we can see what is patentable in India and what is not patentable in India. Okay, I will cover the other part. I will cover the other part of this presentation. You can see here. So IN means, see at one column, you can see the list of inventions. In the second column, there is a country. That is IN means India. US means United States. European countries, UP, Europe. Okay. EP means Europe. US means United States. IN means India. And here in first column, you can see the different kind of inventions. Now we can see what is patented and what is not patented. So whatever the mutants, hybrids, cultivated spores you can develop successfully, that is not patented in India. But mutants, hybrids, seedlings, that can be patented in United States. In Europe also, that is not patented. So the cross symbol means that is not patented. The right symbol means it is a patented. So in United States, you can patent a hybrid. In United States, you can patent a mutant. You can patent a seedlings, but it is not happen in India. You can't patent it. Then various tuber propagated plants that you can't patent anywhere. Tuber propagated plants. Tuber propagated means, you know, potato, okay, sweet potato. Then biological processes of the plants like photosynthesis, respiration, whatever the things which are naturally available, that you can't patent anywhere. Whatever the things which are the result of nature, that you can't protect, that you cannot patent. Biological process of plants. New varieties of plants, you know, the new varieties of plants. If I have developed, breeders develop a new variety of plant, that is not patentable in India. But if it is a new variety of plant, that is patented in United States. Okay, that is patented in the United States. New varieties of plants, seedling, hybrids, mutant, that can be patentable in the United States, but it is not patentable in India. Similarly, the transgenic plants, seeds, that is not patented in India, but that is patented in the United States. Now you will ask, if new varieties, transgenic plants are not being patented in India, so under which rights, under which act it comes? So it comes under the Plant Variety Protection Act, Plant Variety Protection and Farmers' Right Act, Plant Variety Protection and Farmers' Right Act. There you can protect such a transgenic plant, there you can protect such a new varieties, but it's not coming under the Patent Act. then you can't patent plant parts, right? You can see the plant components like specific genes or chromosomes. Specific genes or chromosomes that is patentable in India. That is also patentable in United States. That is also patented in European Union. But that is not, that should not, that gene should be human manipulated. That should have an human interference, human intervention. Only such a genes will be patented. Plant products like oils, pharmaceuticals, that can be patented in India, US, and Europe. Plant culture cells or tissue culture cells, that is patentable in India, in United States, and Europe. See, hybrid plants and seeds, reproductive material, that is not being patented in India, but that is being patented in the United States. Because that hybrid plants, reproductive material, seeds, and everything comes under the Plant Variety Protection Act. Various vectors, various genes, which is involved in the production of transgenic plants, that is being patented in India. So things related, the tools which are being used for the generation of or production of the transgenic plants, like genes, vectors, they can be patentable in India. They can be patentable in United States. They can be patentable in the Europe. New breeding technologies will be not patented in India, but that can be patented in Europe. Nucleotide amino acid sequences, gene sequences, that can be patentable in all three countries, like India, European state, and United States. Protein structure, that is also being patented in all three countries. Genes and genes fragment, DNA sequences and gene construct, which has an human interventions, that can be patented in all three countries. Sorry. Just a minute. So what is patentable and what is not patentable? So DNA sequences, gene construct, they can be patentable in India as well as US and in Europe. Protein structure, they can be patented in India, Europe, and US. Gene and gene fragment, they can be patented in India, US, and Europe. So they can be patented. See, inventions can be patented. Like I told you, what is patentable? The novelty, the invention which is novel, the invention which has an industrial application, the invention which has inventive step. So that can be patentable under the Indian Patent Act, that is 1970. Similarly, there is an in USA, there is an United States course title 35 for the patents. In Europe, it is a European Patent Convention. So what Indian Patent Act can protect? Microorganism. So whatever the naturally available microorganisms are there, that cannot be patented in India. What I'm saying, naturally available microorganisms not being patented. If you will take it as such, you will isolate it as such from nature, that is not being patented in India. But if you manipulate it, if you make any recombinant one, transgenic one, or genetically modified one, then you can patent that one. So that you should remember. So microorganisms with an human intervention, that can be patented in India, that can be patented in USA, that can be patented in Europe. Microbial processes, that can be patented in India, but it should have an inventive step, that can be patented in USA, and that can be patented in Europe. So as I told you, the plant varieties, hybrids, mutants, they are not being patented in India. So in contrast, United States, Europe, there you can patent such a plant varieties, mutants, hybrids. But in India, it comes under the Plant Variety Protection of Plant Variety and Farmer Right Act 2001. So protection of that varieties or transgenic plants is being protected under the which act? It is Protection of Plant Variety, PPVFRA. PPVFRA, that is Protection of Plant Variety and Farmers Right Act. Okay. So now there is one union for protection of such a plant variety, that is European Union for protection of such a plant variety. So whenever we have to register the plant variety under such a protection of PPVFRA or protection of plant variety and Farmers' Right Act, the plant variety, it should be novel, it should be distinct from the existing variety, it should have uniform and stable in essential characteristic. So whatever the plant variety which we are going to register under the Plant Variety Protection Act and Farmers' Right Act, it should be novel, it should distinct from the existing variety, it should be uniform and stable in its essential characteristics. So it should have fulfilled the DUS criteria. DUS. D means distinctness, it should be distinct from the existing variety. Uniformity, it should be uniform, it should have the stable characteristics. So this DUS criteria it should meet if you would like to register a crop variety under the Plant Variety Protection Act. So as I told you, there are various forms of IPR like patent, plant breeders' right, trade secret, trademark, copyright, design, geographic indication, right? So this plant variety, it can be protected under the Protection of Plant Varieties and Farmers' Right Act 2001. There is one more act relevant to that, that is Biological Diversity Act 2002 for the variety protection. So whenever we talk about this variety protection, so how we will know that it is a distinct from the existing cultivar? So for that, the DNA fingerprinting technique is most commonly used technique, which can distinguish the variety at DNA level by using various molecular markers. And you know, there are various molecular markers which can distinguish the varieties, which can distinguish the genotype, which can be distinguish the cultivars based on the DNA sequence. So these DNA markers, it may be RFLP, PCR based marker, RAPD, SSR, SNPs. Okay. So this slight variation in the DNA sequence make them as a distinct, make them as a unique. And that is the criteria for registration of any variety. We say that it should be new, it should be novel, it should be unique, it should be uniform, it should be stable, it should have the stable performance. So that can be done by DNA fingerprinting technique, where we are using various DNA markers. So these are the various application of these DNA markers. Means one can do the genotyping, one can do the plant variety protection by using DNA fingerprinting technique, patenting, then legal application, breeding tools, one can do the marker assisted selection, one can do the marker assisted back crossing, one can test the hybrid purity, one can test the genetic purity of an variety, genetic purity of an cultivar, one can test the trait purity, character purity by using these molecular markers. So DNA fingerprinting by using DNA marker technology is one of the technique where we can use this technique if you like to register a plant variety under the Plant Variety Protection Act. So where you should identify some DNA fingerprint, unique DNA fingerprint for such a cultivar. You know your Aadhaar card. So your Aadhaar card means you have to give the fingerprints. You have to give the fingerprints, and then only you will be identified based on your fingerprint. Similarly, this cultivar can be identified by their DNA fingerprints, DNA profiles. And Alex Jeffrey was the scientist who have invented this DNA fingerprinting technology. And right now, if you would like to do the registration of a variety under the PPVFRA Act, so DNA fingerprinting can be performed. So the banding pattern, you should identify such a unique DNA fingerprints to an individual, to an plant variety, right? So these are the various markers which are used for this DNA fingerprinting, like RFLPs, RAPDs, SSR, AFLPs, ESTs. So there are different act like DNA Identification Act is there in 1994 in USA. In Canada, it is DNA Identification Act 1998. So DNA fingerprinting is mandatory if for the distinguishing of any organisms, cultivars, plant varieties. So all individuals, whatever the populations which resides in USA, all them are have their DNA profile, unique DNA profiles. Like we are having Aadhaar card. More than that, in depth, they are having the DNA profiles for them. You know, if there is a war and if there is an any bomb blast, So the samples are being collected, and based on that sample, DNA test has been carried out, and then we can come to know that who is that individual, what is the identity of that individual based on that DNA sequences. So in the forensic lab, that sample has been sent to identify the paternity, to identify the relatives of that particular victim, right? To identify the some criminals. So like this, all these technologies are using DNA fingerprinting. So here I have to say that if you'd like to register, go for the registration of the plant varieties under the Plant Variety Protection Act, there also you have to do the DNA fingerprinting to identify the unique DNA fingerprint for that particular cultivar. So more than that, there is an, if you have to protect the plant variety, International Union for the Protection of New Plant Varieties of Plants is there. We call it as a UPOV. So you should know that International Union for Protection of New Varieties of a plant. So of course, whenever we talk about the registration of the plant variety, it should fulfill the criteria like dust, distinct, uniform, and stability. And it should be supported by some DNA markers or DNA fingerprints. Then only you can register that variety at such a international level like UPOV, then PPV-FRA at national level. So these are the various organizations: International Union for Protection of New Plant Varieties, Association of Officer Seed Analysts, International Seed Testing Association. So all this needs the DNA fingerprint. If you would like to register the new varieties, if you would like to register the seed, so all this needs the DNA fingerprinting technology. Even if you have to go for the crop notification, if you have to release the variety for the different states across the India, then you can see while filling up that form for registration of that variety, for release of central release of that, for giving the to the central release committee. So the DNA profile of variety, hybrid, inbreed can be made available. So we have to give the unique DNA fingerprint of that variety hybrid, how it is differ from that existing cultivars. So that DNA profile you have to give in this form, and then only your variety is being registered. There only your variety is being approved for its commercialization. Okay, under the PPV-FRA. Now, this our honorable secretary, Dr. Trilochan Mahapatra, Indian Council of Agriculture Research. So he's thinking to make the DNA fingerprinting mandatory to the all crop varieties to avoid the various complications, to avoid the spurious seeds which is being supplied in the market. So that seed can be tested at DNA level to maintain its purity, to maintain its to maintain the purity in the hybrids, to maintain the purity in the seeds. That can be tested at DNA level, and it is possible because of this DNA fingerprinting. Now the government is thinking to incorporate the DNA fingerprinting bill. Okay, so this DNA fingerprinting, whenever we have to register these crop varieties under the PPV-FRA or Plant Variety Protection Act, that time you can make, you should have a particular DNA fingerprint, right? So do you have any questions now? With this, I think I will stop it here. So whatever we have seen now, various forms of an intellectual property, various offices of an intellectual property, what are the different types of an intellectual property, what covers under the, what type of invention, what type of product is comes under the which different forms of an intellectual property, what is the duration of that, or what is the legal authorization time for that particular intellectual property. We have seen about the what is patentable, what is not patentable in India. If plant varieties are not patentable in India, so in under which law it is being patentable? What is the essential criteria for the patenting, like novelty, innovative step? What is the essential criteria if you would like to protect the plant variety under the PPV-FRA? Then how the DNA fingerprinting is supported to maintain the genetic purity of the seed, or whenever we have to perform the whenever we have to think about the release of that crop variety at national level, or whenever we think about the notification of that variety. So the DNA fingerprinting report is mandatory. The DNA fingerprint profile is mandatory. So I will give time for the discussion. If you have any doubt, you can ask it by, you can unmute yourself or you can type it in chat box. You can unmute yourself and you can type it in chat box.